But it's time to stop worrying about the weapons and start worrying about the people who use them. Fortunately, we took a big step towards that today when the U.S. Supreme Court agreed to hear a challenge to the city of Chicago's ban on handguns. This one's big. The lead attorney in that case is also the attorney who successfully argued the D.C. gun ban in front of the Supreme Court earlier this year. He also happens to be the expert we use to help us write the second chapter in our book on the Second Amendment, in the book Arguing with Idiots, which I just found out is #1 in the New York Times list this week. Also #1 in the New York Times list is Common Sense. This is like the 15th or 16th week for this is #1 in paperback. This is now hardcover #1. Thank you for that. Alan Gura joins us now from Chicago. Hello, Alan.
Hi, Glenn.
This is a very big day for anybody who understands that bans don't work to anybody's advantage except for the government. What is the case here? Isn't this an older gentleman with a shotgun that just wants to protect his home?
Yes. Well, I represent Otis McDonald and 3 other individuals in the city of Chicago, as well as the Second Amendment Foundation and the Illinois State Rifle Association. What we are trying to establish is that it's time for Chicago's 27-year-old completely failed handgun ban to go away and join its cousin in D.C. In the ash heap of history. The fact is that gun bans do not work. Chicago has a very sad, very tragic, violent crime problem. That problem only got worse after they banned handguns, and now it's time to perhaps explore other solutions to the crime problem, but as you mentioned earlier. But going after the guns is not the solution. In
this particular case, I mean, the minute you won in Washington, D.C., 2 cases were filed in Chicago, one by the NRA and your case as well. We think there's a good chance that the gun ban in Chicago is going to be overturned, but it's not just guns and the ban on guns that is affected by this case, right?
That's right. The case is much broader than that. The question is whether local politicians, state politicians, have to respect the Second Amendment. In the Washington, D.C. case, all the Supreme Court had to do was determine what the Second Amendment meant, because the Bill of Rights binds the federal government directly, and Washington, D.C. is part of the federal government. But now the question is, what do we do with all these state and local gun control laws? Do they have to pay attention to the Second Amendment as well? And the answer to that, I hope the Supreme Court will find, is yes. You can try to regulate guns in the interest of public safety, but you can't simply enact laws that harass gun owners, make gun ownership difficult, expensive, bureaucratic. Those kinds of laws, including draconian bans like the kind we have here in Chicago, should be struck down, and I think they will be.
When we come back, I want you to answer this question, because I'm a big states' rights guy. You know, as much as I believe in the right to carry guns, in New York, they say no. Isn't that the kind of system that our founding fathers had in mind, that the states get to decide? We'll get more on that here on the Second Amendment next. Alan Gura is here, the lead attorney who will be arguing before the Supreme Court in the Chicago handgun case, which was just announced today. The Supreme Court decided to take it. That's a big deal, isn't it?
It's a huge deal. We're very much looking forward to it.
Okay. He's also the guy that got the D.C. Heller case, the outlawing of D.C. guns, also thrown out. Happens to be the expert that we use to help write the Second Amendment chapter in our new book, Arguing with Idiots. Okay, so here's the conundrum that I'm in. I'm a big believer in state rights. You want to do something in your state? Whatever. I don't have to live there. You want to do it in your community? Whatever. I don't have to live. I don't want the federal government telling us everything that we can do. The Constitution was written, the Bill of Rights was the federal promise, we will never do these things. Why does it apply to states?
Well, Glenn, it applies because after the Civil War, we realized that we could no longer have a situation where the Bill of Rights protected Americans from the federal government, and meanwhile, the state governments were running crazy, oppressing people, engaging in all kinds of terroristic violence against the newly freed slaves. And of course, even after Reconstruction, states began to regulate and legislate and pass all kinds of laws that interfered with our basic liberties. The 14th Amendment, which was ratified, it's just as much a part of the Constitution as anything else in the document. And the 14th Amendment tells the states that they cannot make or enforce any laws that abridge upon your rights as a citizen of the United States. And the Second Amendment is one of those rights. So yes, so long as the Constitution doesn't protect your right in some way, then your local community can democratically make laws. However, the state cannot ban your book, it can't create a church for you to attend, it cannot seize your property, and it cannot take away your guns.
Okay.
That's a decision that we made back in the 1860s, and that's a good decision.
All right. Let me, because I hear Chicago is the same way. On page 48 of the book, they may have to give you a permit, but they don't have to make it easy. It's this chart. Now, do we have it in the big screen over there? Can you show it on the big screen? Here's the chart. It's too bad you can't read it. I'm telling you, spend 2 minutes at the bookstore with this book, and you will just be amazed. This is on page 48. This is what one person in New York had to do, all of the steps, just to be able to get a permit, not to carry a gun, but to buy a gun. Took about a year, and they spent $1,000 just to be able to get the permit to buy the gun. You say it's just as bad in Chicago. Give me some of the things that are up.
Well, it's not quite as bad, but it's pretty bad, and it is something we're challenging. In Chicago, it can take you up to 90 days, and the great thing is when everything is said and done, when you've taken your photographs and gone to the police station and filled out the forms and done everything you needed to do, your permit is good for exactly 1 year. And if you don't start the re-registration process all over again about 90 days before it expires, then you run the risk of having your guns expire. And once they expire, guess what? Your guns become unregisterable, which means that you have to pretty much throw them away or take them out of city limits because you can't re-register that gun, and neither can any of your neighbors. So it's a fairly crazy system.
Wait. Unless you're a guy named Richard Mell in Chicago, you have to meet this guy.
That's right.
Yeah, wait until you meet this guy next. More with Alan Gura. He is the lead attorney who will be arguing before the Supreme Court in the Chicago handgun case. He's also the attorney who won the historic Heller case that outlawed the D.C. gun ban, or lifted the gun. Can you even buy a gun in the District of Columbia now? Can you have one?
Oh, yes, you can have one. You can buy one. It's a little difficult because there aren't any gun stores inside Washington, but that's going to change, I think, very soon.
Okay. Let me introduce America to Richard Mell. This is the thing that I think drives people, makes their blood boil. This is one of the biggest problems we have in America right now is corruption and accountability. And this is what these people always do. They say, no, guns, we've got to be, unless they want one. City Council member Richard Mell, he had a gun collection, I believe, but he forgot to register his gun, right? And so all of his collection could no longer be registered. He had to get rid of all of it. But what did he do?
Well, he proposed an ordinance that would have granted an amnesty to all the people whose guns had lapsed within the small time frame that his guns had lapsed. And eventually the public complained a little bit, and the amnesty was broadened. But what's interesting to note is that Mayor Daley and a bunch of other city officials said, oh, he's not a bad guy. He just wants to have his shotgun so he can go hunting. You know, he's not doing bad things, and we should really, you know, create an amnesty and let people re-register some of their guns that had lapsed. So they recognize that this law does absolutely no good. It's just a gotcha game. It's just something that's designed to make gun ownership difficult and expensive for normal people. But when it snagged one of their own, they were willing to loosen it up, even if only for a little time.
But you can't even, I mean, it's not just guns in New York. It's also mace. I mean, this expands to other things. I mean, in the chapter of the Second Amendment, you helped us with all of the facts and helped us write this chapter. And I have to tell you, the part about assault weapons, everybody thinks that's an automatic weapon, a machine gun. But it's not. The assault weapons ban is not a machine gun. It's a scary-looking gun.
That's right. If it looks scary, they're going to ban it. I prefer the technical term EBR, Evil Black Rifle.
All right. Alan, thank you very much. Best of luck. Big news out of Chicago today. Back in a second.